Welcome to School Law Lectures, Part 2. Today we'll be talking about religion and schools. Religion and schools have always had a complicated history. As we mentioned, a lot of early American education was based in schools that had very close religious connections. Many of the legal frameworks for the establishment of schools, going back to the Deluder of Satan Act in Massachusetts, tied the need for school to reading the Bible. Yet, the Constitution, very clearly in its First Amendment, has looked at the issue of religion from the standpoint of two clauses, the Establishment Clause and the Free Exercise Clause. And these are very different and in many cases contradictory elements of First Amendment, quote, freedom of religion. But it's important to point out that these provisions were provisions that, while in the early republic, many state governments were fearful that the national government would have too much authority. And so the federalist system that was put in place was done so to protect states from the power of the national government. The notion of First Amendment freedoms related to religion are a perfect example. In the early pre-Civil War days, this meant that many state governments actually had established religions, but the free exercise of religion in the Establishment Clause really impacted the authority of the national government to create a state-sponsored religion and limit the free exercise. So what is the First Amendment, Establishment Clause, and Free Exercise Clause? The Establishment Clause prohibits the official establishment of a state-sponsored religion. And again, early on, this focused on the national government established religion. Although later, after the Civil War, the 14th Amendment will apply all of the amendments to both state and national governments. So for our purposes in the 21st century, the Establishment Clause disallows the national government and the state government from establishing a formal state-sponsored religion. The second part is the Free Exercise Clause. This is the right of all people to exercise any kind of religious beliefs they choose. So the freedom of religion is to prohibit the government from establishing an official religion and allowing all citizens freedom of religion, free exercise of religion. As mentioned, the 14th Amendment, around the time of the Civil War, put in place the notion that the Bill of Rights, the first 10 amendments, apply to states as well as the national government. And so this concept of a wall of separation between the church or an established church and the state was one that was advanced very early, but by the period of the 20th century really began a series of cases that began to outline the whole notion of where religion and the state would be. First case, Everson versus the Board of Education, 1947, does sort of draw the line that public tax support for religious schools could not take place. Other cases focusing on the Establishment Clause that are outlined in Chapter 3 of your book include Lemon versus Kurtzman, 1971. This case answered the legal question as to whether or not the government could aid religious schools and whether that aid was constitutional. In answering the question, the court devised a three-pronged Lemon test, as it was called, to pass constitutional muster. The government action or policy must have a secular purpose, neither advance nor inhibit religion, and not cause any excessive entanglement between the government and religion. And this Lemon test lasted for a long time, and is still parts of it are applied today. And so this notion of whether or not, with the Establishment Clause, that there should be a very strict separation between the state and religion, or whether the state should just have no preference on religion, or whether the state should be non-coercive, not coerce anyone in any version toward any type of religion. Those are three very different points of view, and the pendulum has swung between all three of those in really the last 50 years. Probably the most vociferous debate nowadays is the voucher school debate, the voucher debate. The idea of a voucher is that parents can take tax dollars identified for a particular student, and that voucher could go and fund them to go to a private school, religious schools, or any other school. Many states have that. The constitutional provision based in the case Zeldman versus Simmons-Harris upheld an Ohio voucher program, saying it did not violate the Establishment Clause. And a lot of other elements of providing some kind of state support to private or religious schools in what is called the child benefit theory, and a lot of state laws allow for some public funds to support textbooks, release times, and in some cases tuition reimbursements for students, particularly those with special education. As far as cases that relate to the free exercise of religion, probably the most famous case is Engel v. Vitale in 1962. This is the case that outlawed school prayer. It held that school officials in New York could no longer compose a prayer for all students to recite at the beginning of the day. And this sort of set the standard for the outlaw of prayer in schools. In Shemp and Murray cases that came later, they began, as you saw, schools would start to really weasel around after the Engel Vitale case. So one district begins Bible reading, and the Supreme Court ruled that that was unconstitutional. Wallace versus Jeffrey in 1985 even said that silent meditation was unconstitutional. So student-initiated religious speech is about the only speech that is really permissible in schools. Religion that is not foreclosed from schools as long as it's not under the supervision and oversight of the school. So the school cannot cross the line and endorse or encourage participation. That's why oftentimes you'll see student-led prayer and the school not being involved whatsoever. There's also the question, as I said, these two clauses contradict and conflict oftentimes. The notion of at what point do you stop the establishment of religion that interferes with the freedom to exercise in stopping the establishment. Stone v. Graham in 1981 is a Kentucky case that went to the Supreme Court of the United States and ruled that it was unconstitutional to post the Ten Commandments in classrooms. Again, the argument on the part of the free exercise is that students felt like it was their right to exercise religion. Prayer at graduation, extracurricular activities, even non-sectarian prayers legitimately convey or advance religion on the part of the state. That's the whole notion of coercive pressure. People, while they're there at their own will, they don't have a choice whether to listen or not to listen. Probably the main case with the graduation prayer issue is the Santa Fe Independent School District versus Doe in 2000. The U.S. Supreme Court held that a Texas district board allowing student-initiated prayers at football games was unconstitutional. Ultimately, the courts basically said in a majority opinion that students are subjected only to approved messages. Process does nothing to protect minority views, and many students, such as cheerleaders, band members, and the players, are required to attend. These issues in the long history in the school district of prayer at athletic events led the court to conclude that the district asks us, this is a quote from the court, to pretend that we do not recognize what every Santa Fe High School student understands clearly, that this policy is about prayer. One other free exercise case that is well known is the West Virginia versus Barnett case in 1943, which forbade the requirement of participation in the pledge to the flag, cited that as unconstitutional. 1984, Congress passed the Equal Access Act in part to try to create some clarity in this conflict between free exercise and establishment, in allowing the notion that to permit religious groups to participate on the grounds of free speech and their freedom to exercise religion. The Supreme Court upheld the Equal Access Act in 1990 in the Board of Education versus Mergens case. Students have a right to organize their own groups in public schools, religious, political, philosophical. The notion that you disallow this is something called viewpoint discrimination. The interesting thing about this Equal Access Act is that it is also, while it is permitted Bible study in the mornings, religious prayer around the flagpole, religious clubs, and other things where students have that right to access and practice their religion at school, it has also allowed other organizations and protected other organizations, for example, neo-Nazi groups and satanic groups, gay, lesbian, LGBT, gay, straight alliance groups. Those groups also, if not permitted, would be subject to viewpoint discrimination. So they also have, under the equal access right, a right to organize their groups in public schools. The use of facilities is another area where the free speech test and the public forum test are put to use. The Good News Club versus Milford, 2001, that school districts cannot discriminate who uses their facilities. In other words, the school district can't let the Rotary Club use the cafeteria on Saturday, but not let certain religious groups use the cafeteria for certain public forum events that they would hold. So if you declare that you have a public forum and you use your school district as a limited public forum, schools cannot limit speech in the use of facilities, cannot be exclusive based on beliefs. So the cases that you will be looking at and reading and having to look up: Everson versus the Board of Education, the Lemon versus Kurtzman, which we talked briefly about the Lemon test, and West Virginia State Board of Education versus Barnett, which of course is the Pledge to the Flag test. And that concludes our session on the freedom of religion and religion in schools.